Mr. Wu, would you ask Ms. Diamant to activate her video for me, please?
这个 Diamant 小姐，请你把你的摄像头打开。
And Mr. Randich, when's your appointment with Western State Hospital?
Just tell them we're still waiting on the lawyer. Tell them you're waiting to hear from the lawyer.
Right now?
Yeah, he's asking you.
Oh, I guess we're waiting for my lawyer.
Do you think your lawyer is appearing today?
I doubt it. I've been trying to reach him for the last.
We just had a hearing Friday, so we have a scheduled hearing on April 3rd.
You want to talk to him?
Ask if I can talk.
Hey, Your Honor, can my caretaker talk to you?
他说呢，
Your Honor, my name is Maria. I'm his caregiver. He lives in my adult family home. We just had a hearing last Friday, and
Okay, stop right there. We have to have that interpreted. Okay, so Mr. Randich is awaiting an evaluation by Western State Hospital, and that has not yet happened, I'm presuming.
然
that's
后所以
correct.
这个 Randy
And that means Mr. Randich is still pending the criminal charge of assault. Is that evaluation scheduled?
Not yet, Your Honor.
已经约好了，
Thank you.
谢谢。
And Mr. Randich, do you understand what we're doing here today?
I
现在请你，
I do not.
12
I
点
do not, Your Honor.
Ms. Diamant is asking for renewal of the protection order that was entered a year ago, telling you to have no contact with her.
Yes.
And I'm going to renew that order. You still have the pending criminal charge, and you shouldn't say anything about that without your lawyer being present. So you understand that I'm going to tell you you may not have any contact with Ms. Diamant. You understand that?
Yes, Your Honor.
And Ms. Diamant, this order will be in effect for 3 years from today's date. If you want it renewed, you'll have to come back to court and ask for it to be renewed.
Thank you.
Okay, thank you.
All right. Thank you, Mr. Randich. Thank you, Ms. Diamant. I have signed the order. It does not need to be served on Mr. Randich since he is present. It, however, will be available to the both of you through the district court file. And Maria, you understand what I've said today?
Yes, Your Honor.
请问 Maria 女士了解我今天所说的话吗？她说我都了解。
All right. And thank you for being Mr. Randich's caretaker.
You're welcome.
谢谢您今
All right. That will conclude our hearing for today. Shishim, Ms. Diamant. Thank you, Mr. Randich, and Shishim, Mr. Wong.
好，那我们今天这个听证会就到此结束，谢谢各方。Thank you and have a great day.
You too. Thank you, Your Honor.
Yeah, bye-bye. And Mr. Leone, any luck reaching Ms. Oberbillig?
I have emailed and called. My email included the Zoom link. That has been sent across, and I sent that immediately after Your Honor instructed me to.
Okay, but you've not heard back from her? And
No response.
okay. If you don't mind, I'm going to make you wait a little bit longer to see if they appear.
I would be doing the same thing on the bench, Your Honor.
Present, Your Honor.
And Ms. Hunt? If you would,
Your Honor.
if you would both please raise your right hands. Swear the testimony in this case to be the truth, whole truth, and nothing but the truth.
Yes, Your Honor.
Yes, Your Honor.
Okay, thank you. Mr. Stone Cipher, you're a teacher,
Yes. Yes, Your Honor.
and you used to be the teacher for Ms. Hunt's child, is that correct?
Correct. From about February of 2023 to about November of 2023.
All right.
Apologies. To November 2023,
And-
so I had the year incorrect.
During that time, and I believe subsequent to that time, it appeared to you that Ms. Hunt developed an infatuation for you, and she responded to you or in ways that you felt uncomfortable with, and you reported it on a regular basis to your principal. Is that right?
It did not appear to me she had an infatuation with me. After her son had left my class, she gave me a note in April of 2023 confessing as much, and I involved administration immediately because I did not want accusations being leveled against me or to be seen as not being transparent.
Okay. And what's been your communication to Ms. Hunt that you did not want her contacting you in that way?
Initially, she had said she wanted to get together and talk, and I responded with an email saying that I would not prefer to discuss that matter further. I then cut off contact entirely for fear of any action I took being misinterpreted as anything but the same amount of kindness I would extend to all of my parents, current and past. And I had my administrator request that she no longer contact me. She continued to include me on emails regarding her son, on emails regarding her on personal matters. She found my birthday and sent me a personal birthday message. She and her child showed up at my house trick-or-treating. And then most recently, she has sent gifts to my home, naming my child and me and my wife. And it's very stressful considering none of this is wanted, warranted, or necessary, as there is no reason for her to professionally communicate with me.
Okay. And to be clear, on the timeline here, you said that she was contacting you about, I believe you said her son who was in your class. Was that while your son was in your class, or was that after he had left your class?
After he had left, she continued to include me on contacts up to and including after she had been asked not to by my administrator.
All right. Thank you. Ms. Hunt,
Yes, Your Honor.
anything you want to say?
I have a lot to say. Is there anything in particular you want me to cover, Your Honor?
Well, Mr. Stonecipher says that he's asked you not to contact him, that your contact has made him, I'd say, on edge. It is a gentle way of saying it. It's caused him a lot of anxiety, and from the way he's indicating to me, he's made that apparent to you, and yet you continue to contact him. So tell me your version of that.
Yeah, absolutely. Have you gotten a chance to see my declaration pages 1 through 13 at all?
I did, yeah.
Okay, so basically an overview of the situation is at no point did Dustin Stonecipher directly tell me he didn't want contact with me. The closest I got to that was on the May 3rd email that stated he didn't want to talk about personal matters, that he was adjusting his professional hours, and that he was only going to interact with parents concerning their children's education. So I respected that and ended up including him on emails because, as far as I know, he was still involved with IEP projects between him and the other teacher, and I wanted to keep everyone on the same page. I did not have anyone directly say about not contacting him until the June 2nd email from the principal, and then a follow-up call when I talked to him. It sounded like it was advice. And when I talked to the school staff, they stated everything was fine. He didn't have an issue with me. The first time they heard anything was me bringing it up. And this is all in May of 2023. So it was very confusing to me. And then when me and him did have interactions, like him taking pictures with my son the end of the year, he went along with that. He was smiling. When we were coming through his neighborhood, which I can go into the details why we were over there, and I have witness statements to say why I was over there, he was smiling. So I wouldn't have known that he didn't not only not want contact, but that he wasn't okay with interacting with me.
Thank you. Mr.
If he
Stonecipher.
ever directly told me in any communication that he did not want contact with me, I would have honored that. But I did not get that.
So your view is that Mr. Stonecipher hadn't told you not to contact him, and did you think he wanted you to contact him?
No, it wasn't that directly. It's that in his May 3rd email, which I'm sure, let's see what exhibit that is here. In his May 3rd email, he stated that, he was going to be keeping strict office hours and that he was only going to discuss matters appropriate to hit the child's education. He appreciated that I wanted to, clear the air, with regards to misunderstandings between us, but he wasn't comfortable doing that. That's the summary, even though I have the email here. And he can attest to whether that's accurate or not, of course.
Okay, thank you.
And so the takeaway I had from that was that he didn't want to talk about personal matters, but he was fine as long as the contact was consistent with his professional news standards.
Okay. And then subsequent to that, you sent him a birthday gift.
Yeah, so there's a little bit of background on that, so I'll try and keep it brief. So he was an educator that my son really bonded with, and me and my husband were considering whether to have long-term contact with him. So I ran a background check on him. In the declaration, it says November of 2023. That was a typo. It was November of 2022. Okay. Now, background checks weren't abnormal for us because I was a victim of statutory rape of a minor, and I was a ward of the state, and so were my kids in the past. So background checks had to be done on people in close proximity to our family, including my own husband had to be background checked. So if we were considering someone long-term to be in contact with our child, we were going to do a background check. So I did that. I didn't come across his address during that. I was just looking at legal stuff. I did come across his month and year. I came across July of '83. I did not come across the date. I didn't find that out literally until I received the protection order. I had forgotten about that. And then it was either May or June of 2023, I was standing outside the psychologist's office waiting for a meeting, and a lady came by and we were talking about birthdays. And when I got to the month of July, she turned and pointed to Dustin's class and said, "Oh yeah, I think Dustin's birthday is in July." And then that's when I remembered what I had looked up on the background check, that his birthday was in fact in July. And it was '83. I still didn't know the date. And I have this in my exhibits. I emailed him on July 15th. I did not know the day. Put that up. Yes, because I had turned 40 and he had done pictures with my son the previous month. So I thought he was okay with some level of contact. So I sent that to be encouraging. So that's what that was. I have only since my son has left school in June of 2023, I have only intentionally contacted Dustin twice. And those 2 times were his birthday and the gifts that I sent in January of 2025.
All right. Thank you. Mr. Stonecipher, do you have anything else you want to add?
I'm just now finding out about the background check that was run on me. I am background checked through the district. I find that to be highly inappropriate that a background check was run on me. The message in June did say to quit contacting me. It did not stipulate whether it was for personal or business matters. The number of communications and the coincidental nature of the visit on Halloween does not matter to me. What matters to me is that I feel like my privacy has been violated. I feel like I was trying to be polite and not cause further issues because as you'll see in the original letter, Mrs. Hunt did state that she didn't intend to act on these feelings and that she would prefer if her husband did not know about them. And I was trying to be courteous. Additionally, the only reason this was not brought up sooner is the optics of the matter. I am a 6'5" large, very imposing man. I was concerned that people would respond to me in a way that would be belittling and that would be hurtful. And the folks who I have told this to, many of the responses have been. So sending gifts to my family is inappropriate. Sending me any communication is inappropriate. I do not wish to have a long-term relationship with Mrs. Hunt. I still hold a special place in my heart for Nathaniel, and I posed for a picture with Nathaniel because regardless of Mrs. Hunt's actions, he still means a great deal to me, and I still care for him. That said, what she has done has caused me no end of anxiety and stress, and I just want it to be done.
All right. Thank you. And Mr. Stonecipher, does Ms. Hunt's son attend school where you teach currently?
He does not. He has not attended since June of 2023 at my school.
Okay, thank you. And Ms. Hunt, do you have any other children that attend the school where Mr. Stonecipher teaches?
No, Your Honor.
All right, I will find that the ongoing contact by Ms. Hunt to Mr. Stonecipher is in fact reasonably taken by him as harassment and causing significant anxiety. He's made that clear. I believe that in the context of the communications that I've reviewed between the parties, Mr. Stonecipher had made that clear to Ms. Hunt, and she persisted in the communication. Based on that, I will enter the order in this case. Ms. Hunt, you're to have no contact at all with Mr. Stonecipher or his family. You're not to go within 1,000 feet of Mr. Stonecipher, his family, his home, or his workplace. And Mr. Stonecipher, this order will be in effect 1 year from today's date. If you want it renewed, you'll have to come back to court and ask for it to be renewed. And Ms. Hunt, the fact that the order does expire, which is a statutory standard, it does not mean that at that point in time, Mr. Stonecipher wishes communication from you. He's made it very clear he does not. So I would suggest.
Your Honor, I have a question concerning my work because I'm a delivery driver and this makes it very challenging to fulfill my work. And I state this under considerations for my family since I'm the sole provider.
Okay, and what's the concern you have, going within 1,000 feet of the school or going within 1,000 feet of his home?
Both are very challenging because I do not know the addresses in which I'm going to deliver until I pick up the orders. It makes it very challenging to stay off of College Street, which is a very major street through Lacey, which I'm trying to avoid, but I literally have College Street on one side and Ruddle on the other. I'm sandwiched between the two. And either one is either borders his work or borders where he lives. So it's very challenging. I'm not saying I haven't worked on rerouting this weekend to try and make sure I stay 1,000 feet, but it makes it very challenging to do that. Because as I said, I don't know the addresses I'm delivering to until after I pick up the orders. And I would also like it to be considered that I have for the last 1.5 to 2 years avoided going over to his neighborhood, even though the rest of my family goes over there 2 to 3 times a week.
Yep. Okay. All right. Well, that's not going to factor in to me, but I'll give you a little flexibility. I've reduced the distance from 1,000 feet to 500 feet to lessen the impact on your ability to do your job. But with that change, the remainder of the order will be in effect and does not need further service. And if either one of you want a copy of the order, you can access it through your file at district court. Thank you.
Thank you, Your Honor.
Yes, Your Honor.
Good morning.
Morning.
And last I looked on Friday, I didn't see that there had been service on Mr. Eden. Is that still the situation?
No, I received 2 documents that said there were service. Let me grab those. Yes, it says service. One was given, and it said that it hadn't, but then the day after on the 24th that I served the same on 129 within the county of Thurston by delivery personally to Jeffrey Eden.
Hold on. Mr. Eden just walked in the courtroom, so that's kind of a moot issue. And Ms. Pardee, the 2 of you are immediate neighbors, is that right?
Yes, I did you see the diagram I gave you there, Your Honor?
Yes, I did.
Okay.
I've read what you've filed, so I'm just going to ask some questions about it. So 2 of you are immediate neighbors. You've had this ongoing issue, and you believe that Mr. Eden's cameras and lights are intruding on your privacy and meant to harass you. Am I accurate in that assessment?
Yes, Your Honor. That the police also agreed as in the statement or the report they wrote.
I read that. And anything else you were asking me to address by making this petition?
Your Honor, if you notice by the driveway there, Jack, I can't, Mr. Eden constantly, he'll run out to the road and everything because of the setup of the drive. I just ask that he just leave the kids and I alone. They've got just a couple more years to grow up and to go on to do their things. They're making great strides. They've got community supports that are trying to get here. And I just want him to leave us alone. No talking, no videoing of us, no bright lights. The entire front of our house is covered by a carport tarp to keep the lights out from in the front windows and the cameras. You see our driveway there. We'd like to be able to just come and go without being constantly surveilled. There's no reason for it. Sorry, Your Honor. He knows I'm it's like a kid on the phone.
It's okay.
It's stress, Your Honor. There's enough with the land issue that we have to, that shouldn't have anything to do with the kids. They should not be harassed and bullied because their parents had to file a land use issue. That's just above and beyond. These kids can't even go out front in their road to wait for the school bus anymore because of the floodlights and the lights and the spike fence. That's seen by all of their peers every day. And this isn't, they're kids. They're only 16 and 13. They don't deserve to be harassed and bullied by a grown-up.
All right. Thank you, Ms. Barty. And before I go further, Mr. Davis, Chandler Davis, and Hannah B.
Yes.
I don't see you on my calendar, Mr. Davis. Are you in the right courtroom this morning?
Yeah, is that for 9:30?
What do you think you're here for?
I believe it's for
A criminal charge?
yeah, an old one like a warrant.
Right. Okay. See, there are two.
But they might have switched it. I don't even know who my attorney would be on it. Because my last one they had Celia on it, but I didn't even find out that she's not with the public defense anymore until last week.
The calendar this morning. Okay, you're logged into courtroom 3, Mr. Davis. You need to be in courtroom 2.
Oh, okay.
So,
thank you.
Yep, use that login information. And Ms. B?
Hello, Your Honor. I'm here. I'm Shannon Party's caregiver, and I could not be with her today physically. And so,
Okay. All right.
she
All right.
she sent. Okay, thank you.
Thank you. Okay, so I'm reviewing the history here between the two of you, and it looks to me like it gets started in April of 2021. And since that time, you each have had numerous attempts to get orders against the other. Eventually, I believe you just wore the court down, and the court granted, looks like, mutual orders on behalf of each of you. So that's what this case history looks like to me. I don't believe I've been involved in any of those, but I'm looking at the case history. That's what it tells me. It tells me you two are at each other all the time. And okay, hold on. You're filing orders, or petitions, you're filing petitions. You get temporary orders. The court doesn't issue. Finally, the court issued them. Probably January of last year, looks like, and those orders expired on the 16th of January of this year. So, Ms. Pardee, I will ask you a question. Did the presence of that order solve anything for you? Just yes or no?
The order against Mr. Eden?
Yes, for the last year. Did things change?
Yeah. The
Okay.
kids felt okay.
Hold on. I just need a yes or no. And Mr. Eden, did the existence of the order against Ms. Pardee change anything for you?
No, it didn't. I was continually harassed.
Okay, that's all I need to know. Okay. Mr. Eden, I came in and I did not issue an order. Came in last week and we set it for a hearing because he's seeking another petition against you, Ms. Pardee. And on the same basis of all the other requests, and it looks like yours are pretty much the same as well. So I'll come down to this. I'll do what the other judges did. I'll either grant you both orders or deny you both orders, because I'm not going out to the site to see who is slightly more annoying than the other one. I'm not going to do that. So, Ms. Pardee, you want me to issue mutual orders?
Wait, the kids need an order, Your Honor. Yes, the lights won't stop without an order. I have no grounds. I don't know how to help the kids. So I'm working with social services. I'm working with Department for Vulnerable Adults. And this is what they're telling me I need to do. So I don't know what else to do except follow the directions I've been given. And this is the kids want to be able to walk around and they can't. You're comparing apples to oranges. You're comparing an adult picking at children.
Thank you, Ms. Pardee. Thank you. And Mr. Eden, your view on mutual orders?
We've been going through this for over 2+ years. I think you said 2021. I was all for, having the orders, a protection order against both of us, just because of the circumstances, but I realized having these orders in effect, she continues trying to set me up. It's a nonstop thing. I mean, we have the police
So
reports.
what are you telling me? You want no order?
Well, I think it would stop. I would stop these petitions coming back and forth if there was no order, because then she couldn't say I was stalking her children all the time, and she's compulsively lying.
Okay.
So yes, I would not want. I would.
So your view is there should be no orders for either one of you, because it's going to be virtually impossible for me to assess, like I said, who's the more annoying of the two of you, since you guys go back and forth constantly.
Yes.
So you want no orders. Ms. Pardee wants orders.
I'm fine, but it's just, it's
My
you can
children
see, you can
want
see.
an order. Even if you don't give me one, then give the kids one. I don't bring them to court. They don't get to advocate for themselves. They want an order.
Okay, all right. And your children are minors, is that right, Ms. Pardee?
They are only 16 and 13, Your Honor. Yes.
Okay, all right, thank you. And Mr. Eden, what have you done about your lights? Just without being defensive, tell me where the lights are pointing and your cameras.
My lights are, so the cameras, they need to be set as something solid. If there's a tree or anything involved, they go off constantly. So I put them on the road. That's the most solid thing. And that's it. One face is one left, one face is right. I mean, there's nothing I can say. I mean, they're not intentionally trying to harm Miss Pardee or her family. I have never, it's not the intention. This.
Okay, no, don't. I don't need the whole history.
Okay.
The history is really apparent to me. Okay.
And they're my mother's cameras, by the way. It's her property, her cameras.
Well, no, the issue is where are the cameras, and do the cameras, you can regulate the field of vision of a camera. It does not need to be at Ms. Pardee's property at all. It needs to be along your property line. That's fine. Your property is fine. Are you telling me under oath that the cameras their field of view is limited solely to your property?
The cameras are from my property to the road. Yes, they're viewing the road.
Well,
I live on a blank corner. So what's nice about my cameras, so when I get ready to leave my house, if there's a car coming around the corner, my cameras will set off that there's a car coming, because I am on a big hill with a blind corner. So it's kind of nice having the cameras for that purpose. But yes, my cameras.
Do the cameras incorporate Ms. Pardee's property in any way?
With the 60-foot easement? No, they're within this. They're within the boundaries, and that's where her husband is.
Okay, now talk to me about the lights. Do the lights shine towards her house?
No.
You have shields on the lights so that the light stays solely on your property.
It's like having a bow and arrow. You could pull the bow and arrow back, and it looks like it may be pointing in a direction. That bow and arrow could be up a half inch. At a half inch, that is going to be 10 feet off at 500 yards. You come down a little bit. So, just because the cameras look like they're pointing doesn't mean.
No, I asked you about the lights.
No.
Do you have shields on the lights to keep the light spillover? That would be totally annoying if there was a constant light in somebody's window.
Well, the lights only go off when a car goes by. They're not on all the time. I do have a 40-watt light bulb on the American flag. There's a fence, and there's a little, it's a heat lamp. It's so the rain doesn't keep blowing the light out, and it directs straight down the fence line onto the American flag. It's a 40-watt light. And by the way, there's a street light. She never shows the main street light is only 70 feet from my fence. A massive.
It's in that picture, Your Honor.
All right, okay.
The street light's in the picture.
All right, stop. I'm not going to let the two of you go back and forth through me. I know the history here. I've read it. So that's why I'm trying to control this. So I want you only answering questions that I ask. Okay.
The streetlight's in the picture. The streetlight's in the picture. The streetlight's in the picture.
Okay, Ms. Pardee.
Yes.
What's that? Okay, and I don't have one for Ms. Pardee. Oh, yeah. Okay, you're giving me two of these? Yeah.
Will I be able to say anything? I know I don't want to say anything, but it's just.
Okay, just tell me. Mr. Eden was before me last week seeking a protection order regarding the numerous complaints that Ms. Pardee makes about him. and he believes the false statements she makes about him, and also indicating that Ms. Party's children were throwing rocks at his house. And Ms. Pardee has filed, and that was set for a hearing. Since both of you are here today, we're conducting that hearing. And Ms. Pardee, with her petition, has asserted that Mr. Eden harasses her children, and she, in her petition, complained about lights and camera directed at her property. Based on the history of the relationship between the parties, which has been ongoing for a number of years, and the previous attempts by the court to address it either by denying those petitions and say, we're not going to get the court involved, and then eventually giving up and getting the court involved, I'm going to take that latter approach. I'm going to issue mutual orders in this case. So on Ms. Pardee's petition, Mr. Eden, you're to have no contact with Ms. Pardee or her children. You may not say a word to her children. You're not to go onto their property. And in this case, I've ordered as well that any directional lights you have, there may not be spillover onto Ms. Pardee's property. You're going to have to figure out how to shield them if that's what's happening. You can light your property, but not hers. And any cameras that you have, the field of view may not be of Ms. Pardee's property. And that's up to you to make sure that's the case. And as to your order against Ms. Pardee, you are to have no contact with Mr. Eden. You're not to go onto his property. I told Mr. Eden when we had our initial hearing that I don't have the ability to issue an order against a parent saying, don't tell your kid, or if your kids throw rocks at my house, that's a violation of the order for the parent. We don't do it that way. So I'm not going to put any notice in here about that, but understand that that's an issue that Mr. Eden has expressed to the court. And I'm going to direct him today that if he believes that William or Matthew are throwing rocks at his house or doing other things that would be tantamount to the crime of malicious mischief, that you report that as a crime to law enforcement. You don't have to have an order telling people to stop throwing rocks at your house. So this getting an order isn't going to help you in that regard. You just have to call law enforcement, and they'll do an investigation as to whether that's occurring. But that's the way you address that issue. All right. Because this issue has been of long-standing back and forth between the two of you, I've put these orders in effect for double the normal length of time. These orders will be in effect for 2 years from today's date. So for both of you, I hope this buys some peace and some quiet, and you can coexist without having to end up in court all the time.
Your Honor.
So,
excuse me, just a question of clarity. Due to the fill going all the way to the edge of the asphalt, when I walk to the middle of the road, or even if I've gone on my side of the road, Mr. Eden has taken pictures of that in the past and used those to say I've gone on his property. That, in fact, is not the case. The asphalt in my mailbox should be okay.
We're not, I'm not limiting his ability to film a public space.
So would that be, he's got these cameras at my driveway. So my drive is across from his. So anytime we come or go, those lights are facing down my driveway.
Under the court order, it's not to show your property. So if the camera is going across onto your driveway, he'll restrict the view of that. So it's just going to the road. And that's it.
And what about the lights as well, Your Honor?
No. And the lights, the same thing. I've said the light can't spill over onto your property. You can have it toward public areas or his property, and that's it. Okay. I've signed those orders, and they'll be available in your file. Mr. Eden is present in court, and we'll give him a copy of the order since he's here.
So we have another date coming up. The court clerk told me to.
Yeah, we're striking that date. We did it all today.
Okay. And I'm going to make it fast. I wanted to continue on stake because the police reports are flowing in right now, one after another with Ms. Pardee and the violations.
All right. Okay. But as I told you so Ms. Pardee, Mr. Eden also complained last week about the frequency with which you call the police. I told him that we will not use a court order to restrict people from calling the police. At some point, the police will get tired of hearing from somebody who calls them all the time. And that's the remedy to that situation. This court does not restrict people's ability to call law enforcement. But if you really want this situation to die down, hopefully you both just achieve some level of forgetting the other person lives next door and pretend they're not there.
Yes,
All right,
Your Honor.
I signed both orders, and we'll give Mr. Eden a copy of it, and you do not need to be back here for a hearing
On the 10th.
on the 10th.
So
You're all done. You're getting your copy today. All right. Thank you both.
thank you, Buckley, Mr. Buckley.
I apologize, Your Honor. We thought that there was a late start to court today.
There was, but the notice also said that court starts at 9, building's closed till 10, but that's okay. You're here. We won't dwell on that. You get text notices of hearings this morning?
I'm sorry?
Did you get text notice of the hearing this morning?
No, I saw online that there was.
Okay. All right, so I need both Amy and Stacy to raise your right hands for me, please. Swear the testimony in this case to be the truth, the whole truth, and nothing but the truth.
Yes.
Yes.
Thank you. And Stacy, or Mr. Sidzik's current wife, is that correct?
Yes, sir.
And Amy, you used to be married to Mr. Sidzik, is that right?
Yes, that's correct.
Okay.
And Your Honor, I have a question.
Yeah, you asked your question, and I have a question for the council, but go ahead, Mr. Leonard.
Might be about the same thing. We have a motion to engage in formal discovery pending. It was initially before
Right, I saw that.
Judge Meyer on the initial, and he denied it without prejudice. I wasn't even anticipating that it would be heard by him that day. So I'm just renewing the motion. I feel that there's a lot more information, a lot more substance to this case than the petitioner here has been able to glean, given the district's policy on giving out things about employees and about investigations regarding employees. So we would like the opportunity to send them a subpoena and potentially to even have Mr. Pete appear under subpoena to testify as a witness on the behalf of the petitioner.
And the relevance of it to the petition is what?
Course of conduct, the depth of the course of conduct, Your Honor. As of now, we only know about the one report, which I still think, as a facial matter here, would be sufficient given the amount of information there. However, there could be.
Yes, let me interrupt. Sorry. Your theory is that Ms. Sidzik intentionally tried to obtain financial information regarding your client, and her affidavit indicates, "Oops, I made a mistake," and so you're wishing to pursue the allegation that she intentionally is trying to get into the financial affairs of your client. Is that accurate?
And whatever information there also may be there, because there could be other things that were not just the report given to my client. We don't have the substance of the investigation because Mr. Pete cannot tell us. And I'm sure Your Honor takes care in reviewing these files. I'm sure Your Honor noticed the context and timing under which this occurred, being only a mere 10 days after the commission of a child support modification and 7 days after service, or 7 days after service.
Okay. And was information used at the modification hearing?
Still pending, Your Honor. We're set in front of Commissioner Corticray tomorrow afternoon.
Okay. Are there any exhibits from the incident that have been submitted as evidence for that hearing?
We submitted the report that we got from the district in strict reply there. We were trying to keep these matters pretty separate, and I could technically start issuing subpoenas under Civil Rule 26 in that case and get the same information from Mr. Pete, but I feel that as an officer of the court, that would be abusing my privilege to discovery and then using it in an informal proceeding where the legislature said, hey, if you're going to do this, you need the court's permission before you do it.
Right. And I appreciate you asking. Thank you.
You're welcome, Your Honor.
Okay, so, and I'll address the request for discovery in a few minutes. Since the two of you are, I'm assuming you're also appearing in family court on behalf. No,
No.
okay, that's right, because that's the modification is against your client's husband.
Right, I have no involvement with the family matter.
Okay. And Mr. Leone, has Mr. Zidzik filed anything in the modification order that reflects information he would have gotten from his wife as a result of either her intentional or accidental view
Well,
of her pay?
The posture of the case is now such that Mr. Moffat, his family law attorney, in his client's diligence, propounded discovery to us, and we gave him everything they asked for. And we have actually a second set of ROGs now pending that I can't get a 26i with Mr. Moffat on because he's just busy, I suppose. But everything financial wise, we've given them about everything we can, so it's kind of hard to sort the substance out of what was already there versus what was gleaned. But I mean, it's standard for 2 years of all income information to be exchanged in family court. So
Right. Yeah. I guess see if I make my question a little more clear. Is any information, do you anticipate that there's a risk to your client that information that should not have been accessed, that was accessed regardless of why it got accessed, will any of that information be used in the hearing to your client's detriment?
that in that proceeding, I do not have reason to believe so. No.
Okay. So then the reason in this hearing to get into it is because it wouldn't provide information detrimental to your client. You just think it is an invasion of privacy of your client and was done for, if it's intentional, done for reasons of spite or something like that. Is that the essential theory here?
Yes, Your Honor. And I mean, when we look at the statute here, when we look at a course of conduct, the case law is that a course of conduct can occur within 1 day, for instance. But I think that this investigation is going to give the petitioner a lot more information that's kind of crucial to the interest of justice here, of whether or not it happened on more than one occasion. Again, we believe at face that she's already pled her case, but there could be potentially more here that we're not aware of.
Okay, but the potentially more, she would be aware of it if what you're alleging is harassment. So I'm assuming that your client is aware of any of the harassment that's taken place. She's upset to find out that Stacy, I'll just use first names here so we're clear, that Stacy came across her pay information one way or the other, and that bothered her. So it's not like, okay, if we give her the report from the school district as to whether that was intentional or not, that's not going to reveal any other harassment. She would know about if there was any other harassment. Otherwise, it's not harassing.
Monitoring, Your Honor. Our statute also has a 7105 also has the stalking component, which encompasses monitoring, and that's electronic monitoring of somebody. So I think it's very relevant.
All right. And to this point, you're not aware of any other what would be monitoring that Ms. doesn't directly contact Amy. You're wondering if there are other instances of monitoring, I'm assuming is your question here.
And Mr. Peake cannot tell us because he can't
Right.
disclose these things.
I
can't depose him. I can't do anything. So.
Okay. All right.
May I have an opportunity to respond, Your Honor?
Just a couple minutes. Okay, so my review, once again, of Amy's declaration in her petition, Mr. Leone, is that essentially the bullying and harassing she's discussing is the incident where Stacy got into her financial records. I don't really see anything else in there. Am I missing something?
I have a couple more instances I can elicit in testimony, Your Honor.
Okay, but there were not included. Did I miss something in the petition?
No, that's the main thrust of the petition, Your Honor. Correct.
Okay. All right. For purposes of this hearing, I will deny the request for discovery. I don't think that's, I think it's more related to potentially the modification hearing. There's no evidence before the court that anything else has happened. I understand Mr. Leone would like to see if there is other evidence, but the fact that Amy would not be aware of that, in my mind, means that it's thus, by its nature, not harassing, since she has no awareness that it could have happened. So I'll deny the request for the motion. Okay, Mr. Leone, if you want to ask your client some questions. And before I do, Ms. Oberbillig, did you have something else you wanted to say?
It simply related to the motion for discovery, so it's moved.
Okay, go ahead, Mr. Leone.
Thank you. So Amy, what do you do for work?
I am a para-educator in a highly supported special education classroom at an elementary school.
Okay, and how long have you been there for?
I've been there for 3 calendar years on February 14th.
Okay. And how do you know the respondent in this matter?
She's married to my ex-husband.
Okay. And how long have you known her for?
I met her, I believe it was in 2019.
Okay. And
go ahead, I'm sorry.
No, and continue. I didn't mean to cut you off.
I met her when she was dating my ex-husband.
Okay. And your ex-husband is Ryan?
Yes.
So you and Ryan, you guys have a family law case together?
We do.
Hey, what's the status of that case?
It's still active. We have court tomorrow.
Okay. So the active portion of this case, when did that commence?
August 12th, I believe, is when they were filed through the state for child support modification.
What's the difference in income between you and Ryan?
I believe it's roughly around $9,000 a month.
Okay. And what was Ryan's reaction to you starting this case?
He was not happy. He approached me at my daughter's gymnastics with a spreadsheet folded up in his pocket to give to me to show me that I will actually get less in child support if he has to hire an attorney to fight me in court.
Okay. And support up to that point, what had that been from Ryan?
It was an agreed upon amount of $403.
And would Ryan pay that full amount?
No, never. He would always take out sports fees and whatever other fees that he believed I owed him before he would give me the support.
Okay.
Your Honor, I'm going to object to this line of questioning as irrelevant to the issue at hand.
Yeah, I'm giving Mr. Leone a little leeway, but I think we don't need to try the case preliminarily to tomorrow.
It's a foundation, no trial tomorrow,
Yeah.
but foundational, Your Honor, and thank you for the leeway. Trust. Thank you for the court's indulgence here. Okay, so what was Stacy's role in payment of support?
Every now and then she would pay me through PayPal for Ryan, but it was only a few times.
Yeah. And what was your relationship with Stacy leading up to the modification?
I had cut off communication with Ryan and Stacy a good year or so prior to this. There was very minimal contact with her. I had tried to reach out to her one time to see if I could drop my son's sports equipment off for his game the next day, and she just ignored my text message. And then I found out that my son was out of town. So she could have told me then, and I was very stressed out trying to get his equipment to him. So.
Okay. And where does Stacy work?
The North Thurston district office in the finance department.
Yeah. And what caused you to file this petition?
I filed this petition because it was brought to my attention by Derek Pete that she had accessed my files unethically. I was told by Derek Pete that her reasoning was that it was an accident and that I had already given Mr. Sidzik all of this information. But the fact is that I didn't give him 3 years of pay stubs or a financial report. You saw what I had submitted initially in that August 12th packet that I had submitted with my sealed financial documents. I forgot where I was going with this. I'm sorry.
So So you learned that.
Oh, that's right. Yes, I learned because Derek Pete told me that she had downloaded a full financial report of me on her computer.
Okay, so the full financial report, have you reviewed what was filed?
Yes.
Okay, the information on there, what was it?
The information was, it was just a full financial report of my earnings from date of hire till present.
Okay. That same information, are you able to compile that own report for yourself?
I don't think so. I don't know how to get to any of that stuff. I don't access payroll stuff often. It's directly deposited into my account. I actually had to reach out last week to HR to help me navigate finding my new pay structure because I didn't even know how to get to it. I'm not even sure I have the ability to run a report like she ran.
Okay. Your payroll information with the district, do they maintain that on a confidential basis for you?
Usually, I thought.
Stacy, the respondent in this case, has she ever managed your individual payroll?
Never.
Have you ever had contact with her in a professional capacity regarding your payroll?
Never.
Did she have any business in your understanding of her duties to have gone into your file?
No. It's my understanding from what Stacy told me is that she helps to manage bank account information for certain schools. Nothing to do with my payroll.
Okay. So how did, upon this disclosure from Mr. Pete, when was that disclosure from Mr. Pete?
I believe it was back in October. It was in the end of 24. I can't remember the exact time.
Okay. And when this initially happened, back in when was the initial payroll report generated?
I believe that was in August as well, or September, early September or end of August.
In chronology to the family law case, the child support modification, was this before or after you were served with notice of the modification?
After.
Before or after Ryan was served?
It was after Ryan was served.
So how did this make you feel when you discovered that your information had been compromised?
It made me feel even more violated and even more harassed and even more stalked than I already do feel because of our current dynamic situation.
You say even more. Were there any other instances where Stacy was involved where you felt stalked, harassed, or anything else you just said?
There was an incident recently, I guess within the last year, that I had reached out to Ryan, her husband, to ask him for my daughter's soccer cleats because I needed to get her to soccer. He told me that if I wanted them, I was going to have to go pick them up. And I voiced to him that I was running behind and I had another child I was also responsible for to get to soccer, and asked him if he could please help and bring them to soccer. He told me he would put them on the front doorstep and Stacy would put them on the front doorstep for me. I drove to his house and she had sat them on the doorstep, and I got to soccer over 15 minutes late, and a few minutes later Stacy walked up to soccer.
Okay.
She could have brought them herself, but instead Ryan chose to involve her, and she willingly did.
Any other instances?
There was a time when my daughter was having a hard time being away from me. She was in counseling, and we came up with a coping mechanism for her, and that was to put my lotion on her teddy bear. My daughter brought the teddy bear to their home, and my daughter told me that she wasn't allowed to have the teddy bear out. She had to keep it in her room because Stacy was allergic to perfume. Several months later go by, and I'm starting to notice that my daughter is coming home from their home smelling very strong of perfume, and she also got a perfume advent calendar at their home. And little things like that make me to see that I am actively being pulled away from my children and harassed, and everything is being coerced and twisted, and I can't put up with it anymore.
Anything regarding monitoring?
There was another instance where I had taken my children to Lake Chelan for an end of summer weekend trip. I had posted pictures on my Facebook. Just prior to this trip, Stacy had actually texted me asking me where we were going and trying to be very friendly so that I would obviously give her information, which she then later went to my Facebook screenshotted it and sent messages to his family that I was making my children sleep in a garage. It was a fully finished, air-conditioned Airbnb like garage, like it didn't open. It was very nice. But she tried to twist this to Ryan's family members that I was making my children sleep in a garage.
And so what did HR do after they discovered the payroll report?
I was told by Derek Pete that Stacy had resigned. Well, firstly, before that, I was told that there was a report found, and that now that there's been the report found, they were going to run a full forensics on her computer. I waited for some time to pass and I hadn't heard anything, so I reached out to Derek Pete, and then that was then when he told me that she had resigned, and that stopped the investigation.
Okay. Have you reviewed Stacy's reply declaration or response declaration?
Yes.
Was the resignation due, in your own knowledge, was the resignation due to a health condition?
No, since I met.
I'm sorry, hold on a second. There's been an objection. I'm the only fact finder who's not a jury, so you may answer the question.
Since I met Stacy, she's been very open about an autoimmune condition that she's got. She cannot eat gluten, or it makes her very, very sick. She's been dealing with this. I believe she told me that she found this illness whenever she went through her divorce with her previous husband, and she was very sick.
Okay. So what effects have Stacy's actions had on her work life?
Well, due to the ongoing issues and censoring that I have had to deal with for the last 8 years, now that this has happened, it has put emotional duress into my life. I'm afraid now that I am being watched and censored on every avenue. I have had to take a leave from work so that I can manage these emotions and work through them and try to maintain healthy.
Okay. And what are you asking the court to do?
I just want the courts to protect me. I have tried to put up my own verbal boundaries and physical boundaries in the sense of not speaking on the phone and in person, and those boundaries are not being respected. I have requested that we only use the Talking Parents app as well, and that's not being respected either, and I'm just afraid that this is going to escalate, and I need help.
Nothing further, Your Honor.
Thank you. Ms. Oberbillig, do you have questions for Amy?
I do, Your Honor. Thank you. Ms. Sidzik, you indicated that your boundaries are not being respected. Are you alleging that Ms. Stacy Sidzik is not respecting your boundaries?
Yes, by entering into my personal files at work.
All right. Now, you're a public employee, correct?
Yes.
And are you aware that your pay information, including your pay rate and your benefits and what percentage of time you work, is publicly available information?
I'm aware of that.
Can you identify what in the payroll report you felt is private information or not publicly available?
My social security number.
Have you reviewed, I think you testified that you have reviewed the payroll report, correct?
I reviewed the report, yes.
And you believe that your social security number appears in it somewhere?
She saw this first on the screen of her computer. Before you save and print, you have the option of hiding or showing your social security number on this. And I know this because I just did this from my end, from where I have access.
Is your social security number contained in the report?
Not in the report, but it is where she had access into my file. She had to go into my files in order to obtain that report.
Is it your contention that she had access to any private banking information in the report?
Maybe not in the report, but if she got into my account, she had access to everything that I put in there.
Do you have personal knowledge that that's the case?
I don't, because the investigation was stopped. I don't know anything. There have been no findings.
And on what basis then do you claim that Ms. Stacy Sidzik had access to anything beyond what is publicly available?
I don't have my bank account information nor any of my private social, any of that on public knowledge. No, ma'am, I don't.
I guess what I'm asking you is what makes you believe, do you have, I think the question maybe perhaps was already answered. Do you have any personal knowledge that something beyond your paycheck amounts was available to Ms. Sidzik?
I don't, because the investigation was stopped, so I do not know what she had gotten into of mine. I don't know what she got access to. I don't know who she sent it to. I don't know what she saved it to. I don't know anything.
Thank you.
You have any other questions?
Not from Amy Sidzik.
And Mr. Leone, did you have any other witness?
Nothing further, Your Honor.
All right, thank you. Ms. Overbiller, do you wish to call a witness?
Yes, Stacy Sidzik.
Okay, go ahead.
Now, you've already testified in your declaration that you submitted to the court about how you came to access the report. And did you name this report?
No, I did not.
How did it come to have the name Shaban's Amazing Payroll Report?
That is the name of the report that our financial analyst named it. And when you run the report, it automatically is ran as that, and it was ran and saved as that.
Whose report were you initially intending to access?
My report.
When you discovered that you had made a mistake, that you had pulled up the wrong report, what did you do?
I immediately went in and reran my report.
Is it within your job duties to run this report for any North Thurston Schools employee?
Yes, it is.
I want to focus on what the report contains. Did it contain Ms. Amy Sidzik's social security number?
No, it did not.
Did it contain any of her personal banking information?
No, it did not. And can I state that I have no access to any personal information whatsoever? The only access that I have is account codes, which does not have to do with Amy Sidzik's personal information. That it has to do with only accounting for assets and liabilities for accounting purposes, because that is my job description. I deal with account codes only, so I do not have access to social security numbers, bank account information. I have no way of even looking at that on the computer. And my job description can clearly state that.
Did you ever attempt to access her social security number?
No, never.
Did you print Amy Sidzik's report out?
No.
Did you ever send the report to anyone or copy it or photograph it
No,
or do anything with it?
Absolutely not.
So you indicated that Shaban's Amazing Payroll Report was a name given to the payroll report by someone else?
Yeah.
Does that mean that every North Thurston Schools employee payroll report would have that name?
That specific report, yes.
That's all I have, Your Honor.
All right, thank you, Mr. Leone. Questions for Stacy Sidzik?
There we go. Miss Sidzik, you acknowledge that my client has some payroll information publicly available, correct?
Yes.
And you acknowledge that your husband, Ryan, is able to obtain all my clients' payroll information, financial information, etc., via discovery in a parenting plan child support case, correct?
Whatever she supplied, yeah, whatever the district information that she already supplied, yes. I don't know what that information is.
You live with Ryan, correct?
Yes, of course.
There was a certified letter containing the pleadings in the support case delivered to your residence, correct?
I'm sorry, what was that?
There was a certified letter containing the support pleadings in the support case delivered to your residence, correct?
I do not know. It was probably delivered to my husband. I don't have anything to do with any of that, but yes.
Okay. And, you know, he's your husband, so you would anticipate that you would have a discussion regarding change of finances for the family, such as child support modification, correct?
Yes,
And you had this kind of conversation with him on or about August 15th, 2025, correct?
yes.
So the payroll report at issue in this case, Saban's amazing payroll report, or whatever the exact name is, you generated that on or about August 22nd, 2024, correct?
Yes.
And this is 7 days after the it came into your family's knowledge and your own knowledge that there had been a child support modification commenced against your husband in Thurston County Superior Court, correct?
Yes.
Okay, 7 days. So given your previous acknowledgement, would you agree given your previous acknowledgement about what kind of information Amy would have to provide in that case, would you agree that it was unnecessary for you to have obtained that payroll report?
I wasn't obtaining that payroll report.
But you saved it on your computer, did you not?
That was an accident. I was trying to run my report.
Okay. And you didn't delete it, did you?
I did delete it, actually.
Okay.
That's actually, if Mr. Pete would have told you, that is exactly where they found it.
Okay.
In my deleted files.
And the second report that you claim was the correct report. Why was that not provided to the petitioner to substantiate your defense?
Because that's my report. It wasn't anything that I pulled. I pulled my own report.
I mean, you would imagine that if you had something exculpatory, you would give it to your attorney to give to the other attorney, correct?
I have that information if you'd like it.
Okay. And was my client's testimony regarding your duties in finance, dealing with, I guess, banking for various schools within the district, was that correct?
No, that is not correct.
Okay, so what are your duties?
I deal with all the financial accountings. As you can see on the payroll report, there's account codes. It's called an accounting language that deals with all expenditures within the district. I deal with all of the account codes within the entire district, and I do all of that, including paying bills, including journal entries, which is actually what this report is for. There's an account code that's listed on her report, which we do journal entries on a monthly basis for everybody's payroll in the entire district.
Okay.
So my job is accounting, yes.
Okay. So would you agree that the district started an investigation regarding the report found in your computer because it was contrary to district policy for it to have been there?
No.
Okay. Then why did the district start an investigation against you?
Because Amy made allegations against me because she was angry at me, evidently. Because we did a discovery on her and we have a child modification. I don't know why. Retaliation?
Okay. And if Amy started an investigation against you, why wasn't a record of that provided to the court or the petitioner?
There was, I believe there were email traffics that Derek Pete said that he had a phone conversation with her because he believed that there was some information that she was giving him. The email is in her exhibit. I'm not sure which exhibit. So Amy is the one who made the allegation against me. And that's what Derek Pete told me verbally as well.
Nothing further, Your Honor.
Ms. Oberbillig, do you have anything else for your client?
No, thank you.
Thank you. Do you have any other testimony you wish to present?
No.
So, Leonie, briefly, your argument?
Your Honor, definitions before the court, this court's very familiar with. Was there a course of conduct here? Yes, going through my client's files that the respondent should not have had access to at the school district. She saved one to her computer and then deleted it. And then the obvious inference here is that she was sharing them with her husband. Your Honor, this was 7 days after my client had received proof of service. The respondent's husband had received proof of service for the parenting plan, the child support modification. This was to intimidate my client and illegitimately gain the upper hand against her in a child support modification where all of my client's pay information was available to the respondent's husband anyway under CR 26. This was an extreme and inappropriate measure that should not have been taken and was only done really to intimidate my client. So when we look at a course of conduct, it's a pattern of conduct composed of a series of acts over a period of time, however short, evidencing a continuity of purpose. Course of conduct includes any form of communication, contact, or conduct, and that's the part I believe is pertinent to the statute here, or the pertinent to this case here. This was clear conduct directed against my client going through her files. The respondent's course of conduct appears designed to alarm, annoy, or harass the petitioner. And what else could this have been done to do? Look at how it was couched in a chronological timing. It happens immediately after she asked the court to adjust her support obligation. And there was absolutely no legitimate or lawful purpose for this having to occur. Again, self-help is continuously disfavored by the courts. This should not have occurred. Turning to Section V of Course of Conduct, the respondent's course of conduct has the purpose or effect of unreasonably interfering with the petitioner's privacy, or the purpose or effect of creating an intimidating, hostile, or offensive living environment for the petitioner. Both are present here. My client has had to take leave because of the stress she's under from work due to the respondent's actions here. Additionally, under 7105-010-34C, I believe that we're in stalking territory under the statute as well. Any course of conduct involving repeated or continuing monitoring. This was monitoring of her payroll information, stuff that was not available to the public, stuff that my client couldn't even run herself. This was done completely inappropriately. The other instances my client gave in her testimony, though they may seem a little bit more low level, regarding being shamed for her children, quote, being in a garage on a family vacation to Chelan, the soccer cleat incident, the teddy bear incidents, the bad blood, and the underlying animosity from the client is very, very apparent here. This was not done for the innocent reason that the respondent represents. This was unlawful harassment, and my client requests that an order be granted and should be awarded fees for having bring this petition.
Thank you. Ms. Oberbilly.
Thank you. These facts do not support the issuance of a no contact order, even if petitioner's claims, as she has alleged, were true. But that's something that my client has rebutted and denied. There was simply no access here to sensitive or private data, as petitioner has assumed and advanced in her declaration. In fact, much of her two declarations that she submitted to the court are complaining about her ex-husband. Much of the airtime spent in those declarations has to do with him, and he's not a party to this action. This is about a single discrete event in the past that could not even recur, even if the court were to accept that it was intentional, because respondent is no longer employed by the district. This is not a stalking scenario. There hasn't been monitoring or surveillance established here. Petitioner has often offered into evidence some text messages, most of which, or many of which, are between herself and Ryan Sidzik, who's not a party, but where they do reflect communications between the petitioner and the respondent. They don't come anywhere close to the standard for harassment. In fact, the respondent's tone in those messages is actually quite conciliatory and with an emphasis on co-parenting and talking about being on the same team. There's no basis here on which to issue an order.
Thank you. It appears to me and I think it's been acknowledged, the primary motivation for the filing of the petition in this case was finding out that, once again, I'm sorry, but I'm using first names, finding out that Stacy ran a financial report concerning earnings of Amy's earnings history at the school district. Other matters were alleged. Posting of information on Facebook with some negative comments about, at least impliedly, about Amy's parenting abilities. And that's a negative thing. The soccer cleats version, I don't see anything in there that would lead me to believe that was attempted harassment. And then likewise on the teddy bear issue. I mean, I can see how somebody in the position of a opposing party would feel that way, but to somebody like me who's just removed and listening to the facts, I don't find that there's enough there to say that Stacy is aggressively acting out towards Amy out of some resentment over the filing of a petition for modification of child support. The timing of the access of Amy's earnings history is interesting. Is it coincidental? Was it accidental? Was it intentional? You know, hard to see across the board. It could have been any one of those. And if it was intentional, it strikes me that accessing it is one thing, and there may be ways that that's a problem, and Stacy would have to deal with those if they were treated that way by her employer, or if there was some reason to believe that a crime was committed in that regard. But as far as the harassment petition goes, it wouldn't be harassment to Amy if Amy wasn't aware that it had occurred. That is, she couldn't say I was distressed by Stacy accessing my pay report if she didn't know about it. She, however, knew about it because Mr. P reported it to her. And at that point, then it becomes problematic for her. And that's where the argument is, that this is harassment done by Stacy. But I note in that Stacy's not the one who accessed the report, send it to Amy and say, you're not being truthful about what you earn. I see what you earn here, and you shouldn't be petitioning for a modification of child support based on what you earn, or some other comment she might make if she was alerting Amy that, hey, I got you into your financial information, and as a means of harassment or threat, saying I can use it against you. That's not what occurred here. So in this case, I don't know why Stacy accessed that report initially. She's offered an explanation, and Amy's offered the opposite explanation. But regardless, there was no intent to there was no evidence that accessing information was used to harass Amy. It became harassment when Amy found out from somebody else, not Stacy, that it had occurred. For those reasons, I'll find that there's not evidence of harassment engaged in by Stacy against Amy. I will deny the request for the order. All right. Thank you all very much. And Stacy's present in court, and we'll give Stacy her copy. And Mr. Leone can access it. Is that how it's? And Mr. Leone, if you'll access the file for Amy, you can receive a copy of the order.
Thank you, Your Honor.
All right. Thank you. Thank you all.
Thank you.